think this is pretty much representative of my wardrobe.
It's not.
I'm wearing my
I have a
spring
lot of gray
black.
and black.
Yeah.
Yeah, one day, sometimes I mix.
David's
it up.
like, I've
One day
seen you
Will
wear
and Justin
red.
were wearing like the exact same thing. Yep. Gray and black shade. It's a long.
Rachel gives me a bad time. She's like, "Oh, you're wearing black again."
I do have pops of color, but
Okay. All right. Good morning, Chair Postman, members, Garrett Hollendroff, staff and guests. The lobbies are open. Recording has begun.
Thanks, Justin. Good morning, everybody. We'll convene the Liquor and Cannabis Board Caucus meeting for Tuesday, March 12th, 2024. Our first item is a post-session legislative update with Ledge Director. I see you started to smile there as soon as I said post
Yes.
session, Mark. So Mark Webster, sorry.
Good morning, Chair Postman and members, Garrett and Vollendroff. Indeed, the 2024 session is in the books. So our eyes are now going to be shifting towards implementation of all the new work that the legislature has seen fit to assign us. That obviously means a lot of work for Cassidy and the rules team, for Becky in licensing, and for Chandra and E&E. We have to figure out how to pay for it all. So Rachel and finance are in the mix as well. So to start off strong, our agency request bill sailed through with no changes, no votes on its journey to the governor's desk. That journey culminates tomorrow, the 13th, as it's scheduled to be signed by the governor tomorrow afternoon. At that time, the governor will also be signing the Cannabis Lab Accreditation Bill, House Bill 2151. And we've been in talks with our partners at Agriculture around that and how best to ensure that the handoff around Cannabis Lab Accreditation goes smoothly. I think the Adult Entertainment Bill remains the most intriguing or maybe unsettled. We've got a lot of work to do around rules, but some parts of it are straightforward, I think. What we may need to keep an eye on are the current licensees who may want to dabble in that space now that the prohibited conduct WAC was repealed by Senate Bill 6105. I think we've got our first nightclub who's talked about doing so, and I definitely don't think they're going to be the last. I think there's been a lot of discussion during session, and this will be one of the themes of the interim perhaps, around CCRS and traceability. One way that that's going to come up is that Rep. Davis's bill on high potency THC was amended right before it passed to include some reporting requirements for us. So we are to report on the amount of concentrate sold, usable flower, infused products, all that kind of a thing. The range of THC concentration in products in the market, the average THC concentration within the market. So we'll have a lot to keep our eyes on. And of course, we're still implementing the big programs from the 2023 session, like the second phase of social equity, the THC bill. So lots of work to do. And we plan on updating the implementation tracker that you've all seen, that we spoke about last interim, in which the incomparable Jessica Dang designed. So we'll make sure you have access to that, and you can kind of see these are the things from 2023 that we're still working on. Here's the new work from 2024.
Great.
And I think that, this has really been a biennium defined by change, from a change in the director here to a whole lot of new members. And we're going to have a whole lot more, as a number of members announced recently that they wouldn't be returning. Our policy chair in the Senate, Senator Kaiser, is retiring, as is the Senate Majority Leader, Andy Billig. Senator Mullet's not coming back. Senator Linda Wilson, our senator here in Olympia, Sam Hunt, is also leaving. Mullet joins Senator Randall, McEwen, Dingra, Saldana, and Cooterer in seeking another office. I mean, some of those folks may come back, but we are going to see significant change in both chambers no matter what. We could see a real kind of wave of new members, even after the first year of this session was pretty darn high in brand new members. So we're going to be.
Can't hear you. All of a sudden you muted.
Can you hear me now?
Jim and Ollie, could you hear him?
Yeah,
Yes.
the whole
We
time.
can't hear you in the room, so stand by for 1 second.
that's what was.
It just cut you off right in the middle of a sentence. Sorry.
Weird.
It is weird.
Wait, Jim, I can hear Jim. Ollie, can we hear you?
Testing.
Yeah, but
Huh.
Mark,
No Mark.
Testing. Hello.
oh, now you're back. You're back. Okay.
Just have to stand next to
Okay. Yeah. Sorry, Mark. Go ahead.
It's all right. Yeah, you never know. But anyway, we're going to see significant change no matter what. Really could be a real wave of new members, which means that we're going to have to teach a new group of members about our function, what we do and how we do it. So lots to think about before we get to 2025. Happy to answer any questions.
Along with the new governor and new attorney general, we know for
Right.
sure.
Exactly.
And we'll have to educate them too about what we do. One, on the ledge tracker, that includes provisos? Are we keeping track of
It
that?
does. Yes.
Okay.
So
Okay.
those are listed there as well. Yeah.
Okay.
Because we
And you
definitely have a
mentioned-
number of provisos to look after this year.
Yeah. You mentioned, I was going to make this up at the end, but since you brought up the club in Seattle that says they're going to go ahead, Will and I talked about it yesterday, and Will, I kept thinking about it. And so I don't know if Jim and Ollie, you saw this, there's a club in Seattle that announced that it's going to go ahead and do alcohol with strippers next weekend, not this coming, but next weekend, which is not allowed today. That bill that passed is not law yet. And when it does become law, you still have to go to the Department of Labor and Industries and get kind of okayed with the worker safety that's a part of that bill. That was the whole premise of that bill. The people that worked on it call it the stripper bill of rights. So I've been thinking about, well, I think somebody at our agency needs to call that club and give them a heads up now that what they're saying is not what the law says. And we're not currently enforcing the prohibited acts WAC, but I still think it behooves us to try to keep this thing in check in the interregnum here until there is a new law and a new regulation, because I think it really does a disservice to the people who lobbied for that bill, for the strippers or workers too, and the others, which was, this is about worker safety, worker safety, worker safety. And we got a club that says, oh, we're just going to open our doors and go ahead and do it without meeting, the L&I requirements. So I think it behooves us to find somebody here, and I can do it if we want. I just think we need to give them a friendly heads up and say, hey, happy to talk to you about the implementation of this bill, but this is not the way it's supposed to be. And if they do it, it's not, I'm not sure what we do about it then, but we should let that club owner know. So yeah, we can talk about that after. Okay, great. Any other questions or comments for Mark about the session?
Nope. Thank you, Mark.
Yeah, thanks for another great year, Mark. Really appreciate that. Our performance on the our one agency request, but that's sort of like throwing a perfect game. No changes, no negative vote, no votes on either side. So, you're batting 1,000. That's pretty good. We'll give you that one. All right. Either Mark is not entertained or is frozen on the screen.
Probably the first one.
Could be a mix. Yeah, could be the mix. Okay. We are now going to do a quick review on speaking of prohibited conduct. We've got some pending petitions asking us to amend or repeal that, and we have said we would, and now the legislature's also passed a bill that will do the same. And we've talked about this a couple of times, but this is the first time now for Mark just walked into the office. This is very confusing. So we've talked about this a couple of times, but the three board members have not been in a meeting all together for a while. So this is our first opportunity to all talk about this. Daniel, Cassidy, and Justin are all here. Justin's in the room. The other two are online if we have questions. And so, I know we've all had different conversations with staff about it, but okay. We're on a party line today. Member Garrett, what's your preference? Should we start with a brief staff brief on where we're at with this, or do we have questions? However you would like to kick it off is fine with me.
Well, and as I've said to staff, and I even said my conversation with one of the petitioners, that I didn't feel like or see where it was necessary to accept a petition on something that we're already doing that would put us out of our norm of, in the past, when a petition has come to us on something we are already doing, we have denied the petition because we've already opened up rules and things on the issue. And to me, it was more important in a situation where we didn't have to do things different to stay consistent. And from the 6 years that I've been on the board, the first thing I said, I've never seen a petition come before the board that we even knew about a petition within 1 week time frame. That there is normally a process that would take place before a petition comes to us, of thoughtfully looking at it, meeting with other staff members, doing fact finders before the petition is ever brought to us. This situation was unique and was based on a lot of passion and emotion as to what happened. So it did get brought to us out of the norm, but at the same time, what the petitioners was asking us to do is now already and was already being done. So my whole thought on this was, if we didn't need to go out of being consistent, unless we're saying we want to set up something new where the board is going to now start being subjected to picking what comes to us sooner than later and all of those other things, I thought it was best that we stay consistent since we don't have to do it because it's already being done. And that was my thought on the petition at this point in time. And when we first started discussing it, was if it's something that we're already doing and we don't have to go out of the norm, then why would we, when in the past we haven't done it this way?
I have
Yeah,
a
think-
question.
Please, go ahead.
So thank you, Ollie, for that background and for your rationale. I think I tend to agree. However, I have some clarifying questions that I want to ask before I lean into that a little bit more. I do believe in process and sticking with the process and not deviating from it. I wonder, however, in this particular case, I actually have several questions because I'm a little confused about the legislative direction and timeline versus the rulemaking process and timeline. And I think in my mind, I've got it figured out, but I want to make sure I'm not missing anything. Because the only reason that I would suggest that we consider approving the rulemaking requests is if there's a difference in timeline. But like, so for example, if we, as far as I understand, the legislative action doesn't take place until January of 2025. I'm saying that as a question more than a definitive statement. And then wondering what we do in the meantime. What are the implications of us not acting and receiving the rulemaking request, and what are the implications
Jim?
of us receiving it given the timeline? So I don't know if
So-
I was very clear on my question, but I have questions about the timeline. And
I'm sorry, Jim. Jim, can
Yeah.
you hear us now?
Yeah.
You guys all just got hung up on as soon as you said, I have a question. So Daniel may have heard your whole question, but we in the room didn't. I'm sorry. Can we just take it from the top again?
Well, I hope I can take it from the top again.
Well,
I
I'll
can
tell you
do
what,
my
Daniel,
best.
did you hear the question, or Cassidy?
I think I can repeat it, David. Let me just repeat it just for the sake
Up
of
to
getting
you.
it on the record. So essentially, I was saying that I think I'm following everything correctly, but the only thing that I have questions about is the implication of the various timelines. I'm a little like the legislative direction would take effect, as far as I understand, January of 2025. And I wonder if we did accept a rule petition, would that have an implication to timeline? What would we just stand down in the meantime like we said we would? I want to clarify a little bit about the implications. And I guess one final question would be, are there any downsides to accepting it other than we're stepping out of our normal process?
Do you want to?
I can tag that, I guess.
Justin is here. He can take the first swing at this maybe. And then have opinions on it too, but let's hear from Justin.
Good morning,
Justin.
board members. So as
Morning.
far as the implementation for 6105, the way I've read it, and I'm hoping I'm capturing this correctly, Section 2 of the bill is effective on the January 1 of 2025, which is the LNI implementation of the worker protection regulations. The section that has the mandatory repeal of WAC 314.11.050 would actually take effect 90 days after session. And so we're going to see the effective date of the repeal language in there come before the LNI implications for their regulations. And so in June, we'll have the deadline for the repeal, and then we'll have a 6-month delay before LNI is required to have their particular provisions around Section 2 implemented.
Thank you. That's super helpful.
So, I mean, a couple of things. One, remember, Gary, you said, this situation was unique. It was from the start. So I think it's hard to compare it to other things we've done because the circumstances are different. I can't find an example where these same facts existed and that we did something different. In this case, we got petitions. We got a number of them, which is also unusual. It was 5 or 6. All within, a 24-hour period. Most of those prior to us making an announcement that was our intent. So that's one thing that is different is these petitions came to us before the agency said, here's our intention. We also, it's just super unusual for us to say from the start, we plan to set aside a regulation or enforcement of regulation, or we're going to look at that rulemaking. We do that sometimes, and then sometimes we get a petition. This is, again, the only one I can find where the two, sort of come together so quickly like that. The one time that I can recall or that I could find in looking where we turned down a petition because we were in the middle of rulemaking, the petition came long after rulemaking started, and frankly, with the consent of the petitioner who said that was the right thing to do, I was going to ask you to withdraw it anyhow. So I don't think there's, it's different just because this whole thing is different. I don't, the other thing is, and I've talked with all our rules people about this, we have 60 days to respond to petitions. And because our rules team is so busy always, we're almost always pushing that to the end of that time period. But that's not a requirement. It's not to say you have to go 60 days. I would love for us to be able to do that quicker. And Cassidy and I have talked about this. Are there rule packages that are easier, small bites that we can do and get done and move quickly on? Let's do it. Let's not wait 60 days every time. And the main reason we wait on petitions is not for public input, though we've been encouraging of that. It's for agency input. It's so every division has a chance to weigh in and to tell us what they're going to do. We did that. Again, this is why, back to your comment that this situation was unique. It was very unique in that we were kind of forced to do that before we got into this point. So we knew we had long conversations with enforcement, licensing, legal, and leadership about that. And the board had spoken about it. And so most of the time when we do, because of the board schedule, since we only meet every other week, sometimes we're pushing that deadline for the rules team, and they have to do it sooner than 60 days because the next meeting would be after 60 days. So 45 days is probably the average, or I don't know, just guessing. I looked at the ones that we've done in the last, several months and 45 days, which is where we are today. We're just about at 45 days since these petitions came in. So, and then the last thing I'll say is I think the main reason to accept, there's 2 reasons to accept the petition. One is, I think it's an openness issue for us, which is those petitions came to us before we acted. And I think there's something to be said for giving the members of the public the respect of saying, yes, you petitioned us. Yes, we're doing that. The other piece is, which is the only, I think everybody agrees that the pace of rulemaking probably doesn't change no matter what we do, except for one possible thing, which is if we reject this petition today or tomorrow when it's up for action, then the petitioners, any one of those half dozen, have the right to go petition the governor on appeal. And that does have the potential to change outcomes, timelines, and takes control away potentially from the LCB. I am not prejudging what the governor would do, though I know he's supportive of the legislation, and I don't think it would be any different, but that is an avenue, and I just don't know why we would do it. There is no harm in accepting it. I don't think there's any precedent setting that sets an unreasonable standard for us going forward. And we should just kind of confirm that, yeah, this is what we're doing. And if it, in the end, if we don't, I think we'll be fine. I think we'll go through the process, and we're all, I think we all understand the legislature has spoken really fairly clearly about this piece in particular.
Yeah.
And not only repealed it, but in the end included in that bill language a fairly long list of things we can't do to put back in place. So they've gone further than just repeal. They're basically repealing and saying, and you're out of this line of work, folks. So we probably can't do anything too different than what we've got in front of us because of that statutory restriction. Member Garrett?
So I'm a little confused because I thought we've already, regardless, have opened up, number one, a CR 101 that has started that whole rulemaking process, that's already, we're not taking that away, number one. And number two, the point that I made, even though, let's say that they started the petition process, because I think within 2 days, we as an agency heard what the community said, and we wrote the letter to the governor telling them what we would do, which was opening up the CR 101 and to start the rulemaking process. We would never have known that there were petitions out there within a 2 to 3 day time frame. It wouldn't have been brought to the board to even say that there was petitions that soon. And those are the points that I'm trying to point out as far as staying consistent, especially when it's something that's already being done. Rules are open up. CR 101 was done, over 30 days ago? And Cassidy, you can correct me if I'm misstating some of this stuff, because we've had lengthy conversations on how the process would have normally worked. And I explained that to one of the petitioners, and they understood that. They were like, they know when we opened up the CR 101, we heard them, we took action. That was the whole point behind the petitions, was for us to take actions, and that was done. And as one of them said, when they came to the last board meeting, they were happy to see that we had done that and really appreciated the quick response and action from the board. So Cassie, did you want to elaborate more on that and that process?
No, thank you. I think you covered it. Happy to answer any questions, of course.
I'm still not quite sure I see a downside to accepting the petitions, given the fact, I mean, I do, this is a unique situation. This is a very unique situation in terms of things like this that have come in front of us in the way that this came in front of us. And I think when community speaks in the way that the community has spoken, and we're moved to action, we want to encourage participation from the community in rulemaking and in board meetings, etc. And if, again, there's no downside, other than, again, we're stepping from, Ollie, from your perspective, stepping outside of a process, I can't see any other downside. And I'm open. This is what I want to hear. I'm expecting to hear from rules. I'm expecting to hear from others. What is the downside to doing this other than we're stepping outside of a perceived process?
Justin, is there anything you can?
Yeah, I think, the interest points here are the responsiveness to the community, of course, and then also consistency. And so when we're looking at the dynamics, I think this one is kind of unique in the fact that we typically don't always bring notification immediately when we get a rules petition in. But if it is, something that is of high interest to the community and we've received multiple over the same time period, that's what triggers the notification on, board members need to understand that something's going on. And so I think that kind of changes the dynamics here. As far as the benefit, I think either way that the action goes is not really going to change the course of what's going to happen, because we're going to have, we have the CR 101 open. If we deny the petitions, the CR 101 continues to move forward. If we accept the petitions, the CR 101 continues to move forward. We are going to have to make some adjustments in the process based on the legislation, because not only, when we opened the CR 101, we said we're going to explore rulemaking, and that could have meant modifications even. Now we have to do a repeal, and that repeal also is going to have some crossover into other areas of rule that we have to take out of rule, for example, penalty guidelines and those types of things. And then there's also references in other parts of the regulations that refer back to this particular rule. So there's going to be a broader type of rule development that is going to need to happen. We haven't decided on the rules team whether or not we want to do a modified CR 101, if we want to go through the repeal and then just do the cleanup in the other sections separately. But I think as far as if you move forward with accepting it, it's going to move in that direction. Or if you deny it, the one risk around the denial is the appeal to the governor's office. And that could come back as we expect the agency to engage in rulemaking, which the response is going to be, we already are. And so again, even with the appeal, I don't see the course changing from this particular standpoint.
Have we ever had anybody appeal to the governor's office on a rule petition that we've denied?
Not that I can recall off the top of my head. I believe I've heard there has been, but it has been a very long time, and before I was in this particular position. So I don't think that we've had anything in the recent years.
Well, let's not make this our first.
So would there be a reason to appeal to the governor's office on us doing what the petitions are requesting? Why would someone, and this is just my thought, why would someone appeal not accepting the petition if we are already doing it?
Only if they felt that it was a sign of a lack of commitment to the issue. I think everyone who's submitted the petition understands what we've all been talking about here. I think we all know what is real. And I think it really comes down to, is it an opportunity for us to just, and the more we drag this out, the less and less meaningful it is to say, yeah, we agree. Thank you for sending these to us is basically what we're saying. And that's all this is she strikes me as just a little courteous nod to the people who have reacted very quickly. And again, where is really, I think, a distinction from other cases that I'm aware of, came to us.
I'm okay with whatever decision you and Jim make. I'm just staying firm on being consistent, but I respect what you other board members would like to do.
And I just want to say that I hope for staff, like, inconsistent is okay if what we're talking about is a different set of circumstances or moving something quicker. Sometimes what people get really frustrated about government is when government says, well, that the process is such, and they go, well, the circumstances are different. We go, well, but the process, and it usually takes us, so we're going to take 60 days. I think I hope we get more like this, that staff can come to us and say, hey, everybody on board loves this one. It's only been 10 days. and we've already said we're doing it, but we should accept this petition, I'm gonna go, right on, let's do it.
I agree with the process, need to speed up, all of those things I agree with. I'll be the first person to say it takes too long for the process and all of those things. So those aren't the concerns that I have. The concerns I have is just being consistent and having been, especially when we don't have to. That's just my stand on that. But like I say, I respect you all's decision, but that's my stand on that.
I think we've spent enough time on it. We'll get it on the agenda tomorrow. So we'll have an opportunity to see if we vote on it tomorrow.
So can I
Yeah.
make just one point for tomorrow? So the staff recommendation will come in as you've seen it before, as a recommendation for accepting. Now, that doesn't mean that you all can decide tomorrow that you would like to vote against it. So don't feel like voting against the staff recommendation makes any different. So if you're thinking about it tonight, and you go, you know what, I think I'm actually gonna look at it from a different perspective, that's perfectly fine. You know, staff's not gonna be offended by that, but just to prepare you that the staff recommendation comes out as the same as it has been.
Understood. And I think it's worth noting that when we talk about consistency, it's highly unusual for us to vote in a way other than what staff recommends. But in fact, we do it sometimes.
Yeah, absolutely.
In fact, you remember we did it on DDT when staff wanted to do emergency rulemaking and we said no. So consistency. Okay, so that's it for that. Let's now move to the rest of our update and prep for tomorrow's meeting because we have some other, we have another petition and other steps. And Cassidy, I will turn it over to you for that. Thanks, Justin.
Great. Thank you and good morning, board members. So I'll start with the cannabis updates. Tomorrow, for Daniel's working on the medical cannabis endorsement project. He had a engagement session yesterday and he will have another one tomorrow at 2 p.m. on Thursday. And so that's reviewing this draft rule language. And based on the feedback that we get at this next session, it will determine whether or not we hold another round of engagement and based on revisions to the draft rules. But we would expect that that's likely going to happen. Okay, and then for the THC bill, we're hoping to send the draft rules later out this week or not today, but we'll hopefully send out an invitation, at least holding the dates. And hope to hold stakeholder engagement at the end of March. Also at the end of March, we will be sending out draft sampling rules and then holding engagement on those draft rules in April, mid-April. And then we also have, so next week, Denise will be bringing a 101 to the board regarding the minors on premises petition that was previously accepted. And then also next week, which I'll get into I'm sorry, not next week, at the next board meeting. She will also be presenting the 105 for the prohibited conduct expedited rulemaking regarding tobacco penalties for penalties for selling tobaccos to minors. Okay, and then let's see, we have a lot. For social equity, we're on track there. We're in the process of drafting rules internally, and next steps will be holding stakeholder engagement to review and discuss that draft rule language. We're still hoping to file the 102 at the end of May with a public hearing to be held in July, just again, based on that board calendar. And then the 103 would be filed in August with rules effective in September. Prohibited conduct, I'm not going to go into that because we just talked about it. And with that, unless there are any questions, I can preview the petition response I'm going to present tomorrow.
I have one quick one on the social equity outreach. Is there a plan now on what that all will entail? How many meetings?
So we'll probably, of course, all of this is tentative and we're estimating because it all kind of builds off each other. But the plan is for now that we'll disseminate those draft rules. We'll hold engagement. We'll likely have to go back and revise those rules based on the information we receive, do another round, and then we'll do the 102. So we've built into our plan some time to be able to do both of the stakeholder engagements.
When we know more specifically what that engagement looks like, we just share that plan with us so we can see what the meetings are, and that'd be great.
Absolutely, yes.
Okay.
And we're hoping at the end of the month, maybe sending out those invitations, or just tomorrow I can give you a better update on that timeline.
Right.
Okay. Okay, so today I'll briefly preview a petition response or response to a petition that I'll be presenting to the board tomorrow. The petition was received on January 25th by Chuck Olivier, who's a concerned citizen. He's requesting that the board consider rulemaking to amend WAC 314-55105, and those are the packaging and labeling rules, to require the date usable cannabis is harvested, the harvest date, and the date cannabis concentrates are processed, processing date, to be on retail product labels. And I'm going to refer to them as dates moving forward. So according to the petitioner, not having the dates on the labels hinders consumers from being able to make informed purchasing decisions, which could lead to purchases of contaminated products that might be harmful, or not necessarily knowing what the cannabinoid content is in that product, just because that changes over time. The impetus for the petition stems from concerns about the quality of sun-grown cannabis, and particularly because it's harvested seasonally and then stored long-term. So to develop the recommendation for the board, we reviewed the merits of the petition, which included how quality and stability of cannabis changes over time and the potential impacts to consumer safety, as well as the potential benefits of the petitioner's request, including how increased transparency may affect consumer behavior. We also included practical considerations such as the feasibility of what the implementation would look like if we were to move forward with rulemaking, and then also implications for the market. So tomorrow I'll be recommending that the board accept the petition to initiate rulemaking to consider amending the packaging and labeling rules to require the dates on retail product labels. And I'm happy to answer any questions.
Do you know yet what other states, are there states that do have a grown date on the label?
Yes, we did a post on Canada, and I believe it's a less states than there are that's doing it, and I think a much smaller percentage. I want to say like 4 or 5, but I can give you exact numbers tomorrow.
I think it's a great conversation for us to have personally. I mean, when I look at produce, for example, I always look at, and it's not exactly the same thing, but I always look at the harvest date. And when I talked to Cassidy, I used apples as a specific example, where apples can be stored for a long period of time and you never know what year, but you can sure taste the difference. And so I just think it's an important discussion for us to have.
Right.
Yeah, it's interesting.
Yeah, I'm surprised it hadn't been brought up sooner.
Yeah.
Well, as it, sorry, I hope I'm not interrupting. So it actually, in 2018, there was a rulemaking to amend the packaging and labeling rules, and that is when the harvest date was no longer required, but was an optional labeling requirement at that point. And so
it was required prior to 18?
Yes, it was.
Oh, well, it'll be interesting to hear what that discussion and decision point was. Why did we move away from it? Huh?
Yeah, happy to get into that tomorrow or right now, whatever you'd like.
We can do it tomorrow.
Why did we move away?
Go ahead. Go ahead. No, go ahead. You can answer that question, Cassie.
Well, a few things. So previously, whenever the rule was put in place, we had a different system for traceability. So without the date on there, we would still be able to track the product through the system. However, in 2021, when this LEAF changed to CCRS, the capability of kind of those traceability generated unique IDs for products was no longer happening. That's CCRS doesn't generate those unique IDs. And so there's kind of a disconnect, if you will, in now what our traceability can do and what the intention of removing the requirement was, which is less compliance burden for businesses while also not, impacting public safety in a negative way, or public health.
Yeah, I remember that now when we went from one system to the other system.
So just
Right.
a point of
Okay.
clarification or question, in the previous version where we did take the data, was that also consumer product information or was that just internally used by us? Because as I'm hearing this, and actually this is another question. This is so that consumers also will know with the harvest, right? And so
Right.
what was the previous consumer or internal use only?
That's a really good question. I believe that's a really good question, but I will let you know tomorrow.
Okay.
Okay, thank you.
If we were to do this, does CCRS have the capability to add that date in
So,
a useful way?
yeah,
Not that you're the IT person, but
I've talked to our CCRS team, and they are working on putting some additional trackers in there, like created date for packages, and I can't remember the specifics right now, but yes, they're working on it. I think it's going to take some time to put that in place. So we'd have to time the rollout accordingly, of course, but I wouldn't even expect it. We would, if you guys accepted the petition and we move forward with rulemaking, I wouldn't expect it would happen until after like fall next year, just because of the legislative rulemaking we'll have to do.
So Cassidy, I also remember back then, a lot of the concerns for the industry was having to have so much things on the packaging and having to put so much on the packaging. So I thought part of it back then also was the industry requesting us for them not to have so much, having to put so much on the package. Is that correct?
Yes, that is correct. And so if as we consider rulemaking on this, we definitely want to look at trade-offs. So do we need all of the
Right.
information we currently have on the package? Is there an alternative way that we could provide this information without having to do rulemaking? So accepting the petition allows us to kind of begin those conversations.
Okay.
All right. Thank you.
Thank you.
thank you. We'll do that tomorrow then. Okay, looks like that's it then for rulemaking. Board member and executive assistant reports. Justin, anything?
Not for me. Thank you, Chair.
Members, Garrett or Alondroff? No.
No.
The only thing I'll add before we go is today flags are flying at half-mast at the governor's order. It's the memorial for the Washington State Trooper Christopher Gadd, who was killed in the line of duty last week. I just want to mention that to say that, our thoughts are with his wife and 2-year-old daughter and his friends and family. And the other is, all law enforcement feels it when there's loss, and we have law enforcement officers here too. And I want them to know that we're thinking about them today too. I know some will probably be part of that memorial. Trooper Gadd was 27 years old, and he was the top ranked cadet academically in his class, and probably done anything in life and chose to commit to public service and gave his life in line of duty. So anyhow, our thoughts are with him and his family and his friends and all law enforcement. And with that, we will adjourn. We'll be back tomorrow at 10 o'clock for the board meeting. Thanks, everybody.
Thank you. Bye.